So last segment, we heard about the impacts on Sangamon County for the beginning of the end of no cash bail. Sangamon County Sheriff Jack Campbell is my studio guest. But earlier this week, you had a coalition talking about the impacts of the no cash bail, in particular on those domestic violence victims. And one of those part of this coalition supporting the end of cash bail was Eric Reinhart. He is the Lake County State's attorney, and he spelled out some of the things that he thinks are misconceptions about the no cash bail provisions in state statutes.
The biggest misconception, I think, and it started out and it kind of became a pyramid. If you think of a pyramid, I think this misconception funneled a lot of things forward. I think in the community and in some law enforcement, in good faith, some law enforcement communities, the word detainable became intermixed with the word handcuffable, which, by the way, is not a word. And I think police officers thought that they were going to be checking their cheat sheet under the Safety Act as to whether or not they could handcuff a retail thefter. Thefter isn't a word either, by the way. Whether or not they could handcuff a retail thefter. Okay? That is the biggest misconception, is that detainable became synonymous with handcuffable. That I can't handcuff a retail thefter. Not true. Not true at all. Everybody who is accused of committing a Class A or misdemeanor or a felony can be handcuffed. And many individuals who are accused of committing Class B and Class C crimes can also be handcuffed. The question is pretrial detention. And pretrial detention only starts when you see a judge. So the offenses got split into detainable and non-detainable at the moment of seeing a judge. Detainable and non-detainable means what are the options that a judge has in front of her or him as she or he thinks about trial. It is not a law enforcement term. At the same time, what I will be honest, I think, and I don't mind saying this, is a much smaller reform. Police officers were directed to not handcuff cooperative individuals who were not a threat to anyone, who were accused of committing a very small class of crimes, what we call B and C misdemeanors. Those two things got smashed together. That is, I think, the biggest, most base misconception that happened with the Safety Act, and police having valid, good faith concerns about all of those distinctions is what powered a lot of this.
So Reinhart, again, a Lake County Sheriff, or Lake County State's Attorney, talking about how the Safety Act is going to impact victims of domestic violence. And that was another area he talked about.
That this is such a pro-safety, pro-victim measure that does encourage immediate accountability for the offender. And by the way, that just because you're in a jail for some period of time doesn't make everything into a 20-year prison sentence, right? That this in a much better way allows us to calibrate the safety issues, to connect with Kayla's point that it isn't one size fits all, but that actually we will be making safety-based decisions instead of I can't think of the word, sort of disconnected decisions when it comes to we don't know how much money somebody has. And it doesn't really solve the problem to say everybody gets a $5 billion bond. Well, if everybody was getting a $5 billion bond, people wouldn't be posting and we wouldn't need to change the system. We know that we have to have an intentional system that focuses on safety, that frankly excludes some offenses, nonviolent offenses, so that we can treat substance abuse disorder and mental illness as the health issues that they are, as opposed to the incarceration problems. And that the Safety Act really does a great job of splitting that, of dividing that, and that there will be accountability, and that there will be accountability on the front end, and that it makes everybody much safer. It's a lot of work on the front end of a case. Many people are used to the intense legal work of a case happening at the end as everybody is headed towards a trial. But that's not where a survivor of a crime is. 14 months later, they're in a different place, maybe literally in a different place. And that actually discourages accountability. Or maybe there's been manipulation of a survivor since the incident 14 months earlier. That discourages safety. And so when we think about offenders being in custody on a short-term immediately and for the immediate and for the foreseeable future, that is going to encourage rehabilitation. Actually, that is going to encourage us getting to the truth, because we're losing some of the truth when offenders post bail and then manipulate their victims.
So again, just some of the ins and outs as seen from the eyes of a supporter of the Safety Act. Eric Reinhart, Lake County State's Attorney, talking earlier this week with a coalition addressing how domestic violence victims, they say, are going to be better served by the end of cash bail. So rather fascinating to hear the arguments. Again, they say that, somebody who's accused of domestic violence could have cash bailed out at one point and put the individual in jeopardy, the victim in jeopardy, but now they have more discretion to be able to hold such people and have more transparency, as the advocates say on this issue. So Monday's going to be an interesting day to see how all this comes together. Then, as we heard from Sheriff Jack Campbell, they're going to hope to compile data to kind of illustrate whether or not the Safety Act is indeed making the streets less or more safe. So plenty more to talk about on this, no question.